A pseudonymous entity, Noah Doe, filed a lawsuit in the New York Supreme Court to legally claim 39,069 dormant Bitcoin addresses. This claim covers 3.8 million Bitcoin, roughly 18% of the total global supply. At current market prices, this equates to a valuation of $293 billion. The targeted list includes some of the most analyzed wallets in cryptocurrency. Among the defendants are the Genesis-era Satoshi wallets, widely attributed to Bitcoin's creator, Satoshi Nakamoto. The list also includes addresses holding contested assets tied directly to the Mt. Gox exchange hack. The cryptocurrency industry has largely reacted to this filing with outright mockery. The prevailing belief rests on a core maxim: not your keys, not your coins. Industry experts assume a court order is entirely useless to a plaintiff who does not possess the private keys. That skepticism is rooted in the mathematical mechanics of a distributed ledger. A judge can issue a ruling, but the Bitcoin protocol cannot read it. The network only authorizes a transfer of funds when a valid cryptographic signature is provided. Dismissing this lawsuit because it cannot bypass cryptography is a miscalculation. The plaintiffs are not attempting a technical attack on the blockchain. They are executing a precise legal maneuver targeting the regulated fiat gateways. The vehicle for this maneuver is New York's Lost and Found statute, Personal Property Law Article 7b. Drafted in 1958, the law was built for physical, tangible items. It provides a legal framework for someone who finds a leather wallet dropped on a sidewalk or a piece of jewelry left in the back of a taxi. Noah Doe bypassed the physical world entirely, developing a custom algorithm to scan the public ledger, flagging wallets that sat dormant for at least 5 years, ignoring massive price appreciations. To comply with the statute's requirement that a finder deliver lost property to the police, the plaintiff executed a physical maneuver, downloading the lists of public addresses onto USB thumb drives. He then walked those drives into the NYPD's 17th precinct, handed them over the counter, and collected official police property invoices in return. As attorney Ian R. Cohen outlines in an amicus curiae brief opposing the suit, this approach strains common law definitions. Scanning a public ledger constitutes data surveillance. It is not the physical finding or possession of a lost object. The plaintiffs are attempting to force a borderless cryptographic network into a mid-century state-level property law by arguing that observing data is legally identical to possessing it. Article 7b establishes strict timelines for found property. If an item is valued over $5,000, the statute mandates a 3-year police holding period before the finder can claim legal title. The actual market value of the targeted addresses averages millions of dollars per wallet. The statute contains a specific loophole. Section 257, subsection 2, provides a shortcut for property valued at $10 or less. For these nominal items, title automatically vests to the finder after exactly 1 year, entirely bypassing the multi-year police custody requirement. To access this fast track, the plaintiffs hired an expert to testify these wallets were less than $10 as is. The logic hinges on missing keys. Without private keys, recovering the assets is practically impossible. Therefore, the addresses are functionally worthless. Applying this sub-$10 valuation allowed the plaintiffs to argue that legal title to 18% of the global Bitcoin supply rapidly vested in them across late 2025 and early 2026. The $10 appraisal is not an assessment of financial worth. It is a calculated statutory exploit designed to bypass legal friction and secure ownership before a defense could be mounted. The under $10 shortcut carries one final requirement. The finder must demonstrate a reasonable effort to locate the true owner. The plaintiffs designed an on-chain notification strategy. They hired a cyber expert to use the OP-return function, appending a tiny text message directly into the transaction records of all 42,000 initially flagged wallets. That OP-return message directed users to a web page hosted by Salomon Brothers Strategic Advisors. The site offered owners a strict 90-day window to claim their cryptocurrency. To legally fortify this effort, they supplemented the blockchain messages with a global press release, pushing the notice to hundreds of media outlets. The notice campaign yielded a specific result. Holders of 424 addresses proved their ownership by moving their coins on-chain and were dropped from the suit. That left 39,069 silent addresses as the remaining defendants. The plaintiffs applied legacy definitions of due notice to a privacy-centric digital network. They relied on the fact that early cryptum adopters practicing strict operational security would be highly unlikely to click an unknown web link within a 90-day window. Noah Doe petitioned the court to hide his own identity while filing the suit. He justified this anonymity by citing the severe risk of kidnappings and physical wrench attacks that target known large-scale Bitcoin holders. Before filing, Noah Doe constructed a complex corporate architecture. He transferred 98% of his interest into an irrevocable trust, routing the West through ABC and XYZ Company. These Wyoming LLCs leverage anonymity-friendly corporate laws, effectively building a fortress around the plaintiffs' identities. The plaintiffs use state-sanctioned anonymity to avoid physical threats, yet the lawsuit would force the actual wallet owners to publicly dox themselves in a New York court simply to defend their own assets. This corporate architecture functions as an offensive tool. It creates a weaponized asymmetry designed to make defending the property vastly more dangerous than the act of the claim itself. A New York judge cannot force the Bitcoin network to hand over private keys. The plaintiffs fully understand this limitation. The actual objective is to secure a declaratory judgment. This creates a cloud on title, a legally recognized defect in the ownership status of the assets. The trap snaps shut if an early adopter eventually decides to sell. If they move their dormant Bitcoin to a regulated, centralized entity, like Coinbase or a Wall Street ETF custodian, the legal defect activates. Centralized exchanges operate under strict compliance rules. Faced with a valid New York Supreme Court judgment presented by the Wyoming LLCs, the exchange's compliance officers will immediately freeze the incoming assets to protect themselves from secondary legal liability. The plaintiffs do not need to break Bitcoin's cryptography. They have built a legal toll booth directly at the fiat off-ramps, where the decentralized network is forced to interact with the legacy banking system. Once the exchange freezes the funds, the original owner faces a severe ultimatum. They must either abandon millions in assets or fly to New York, hire counsel, and publicly step forward to prove they own the address. This maneuver subverts the core promise of Bitcoin, dismantling the right to self-custody and pseudonymity by routing property rights through a state court judgment. If New York validates this lost property framework, the tactic will be replicated. Algorithmic bounty hunters will immediately begin scanning every single public blockchain to legally hijack any address that sits inactive. The Noah Doe lawsuit represents a stress test for the entire ecosystem. It asks whether traditional legal capital can systematically short the institutionalization of decentralized finance.